The advocacy for Nigeria to fully adopt virtual proceedings through digital platforms in all courts has intensified. Although Lagos and Borno states have started this procedure due to the closure of the courts in Nigeria as a preventive measure against COVID-19, many lawyers have commended the move. But there are concerns that this switch may not be in concert with the Constitution of Nigeria, which stipulates that all court proceedings must be held in public. Now the Senate is considering a bill proposing an amendment to the Constitution to legalize remote court proceedings. The Constitution of the Federal Republic of Nigeria, Bill 2020, has sailed the first reading. The chairman governing body of the Justice Reform Project and senior advocate of Nigeria, Funke Adekoya, joins us now on the news and tells us a thing or two in this regard. Thank you for joining in, Madam Funke Adekoya. San.
Thank you very much.
All right. So, straight to the point, you are in support of the remote court sitting, but why is Nigeria struggling to adopt this initiative?
I think it's possibly the fear of the unknown. People are used to doing things a certain way. As the COVID pandemic have shown us, ways of the past are not the ways of the present, and they're not likely to be the ways of the future. I think that is the basis for resistance or the concern that virtual court hearings are not constitutional.
So the fear of launching into the unknown and trying out new things. Now, the bill to adopt online platforms for court sittings will have to pass through the National Assembly and all states in the country before it becomes a law. What will happen in the meantime to all the cases pending in courts?
Well, firstly, I don't think we need an amendment to the Constitution. The section that people rely upon, section 36(3), says the proceedings shall be in public. It does not say should be in a particular place. The Interpretation Act also defines, the Constitution nowhere defines public. Defines public service, defines public servants, but does not define public. The Interpretation Act also does not define public. It defines public as a place to which people have access. And therefore, virtual court hearings are a place to which anybody can have access if properly organized. I do not see virtual court hearings, therefore, as being unconstitutional in any shape or form.
Finally, how do we ensure that the court users are not shut out from virtual proceedings due to the connectivity hurdles?
Well, this is another issue. People go to the physical court premises, and the court premises are so small that people do not have access. That does not mean that their lack of access makes it unconstitutional because they can't enter the court and listen to the proceedings. So where connectivity is a problem, it does not make the proceedings unconstitutional just because somebody could not access the system. As long as the facilities are available to enable me click on a link and access that virtual courtroom, then I think the constitutional provisions of shall be in public have been complied with.
You sound like this would be a smooth sail. What do you think?
It would definitely be a smooth sail if people just open their minds to the possibilities. For anybody who's been involved in international arbitration, we're used to these virtual court arbitration proceedings online because people are in different countries and the cost of travel make some of these virtual arbitration proceedings normal as of now.
Thank you so much, Funke Adekoya, SAN. Thank you for being a part of the show.